Hey guys, this video is for government. Hello seniors. I'm going to be posting a few things on Google Classroom for you. I'm going to post a Federalist number 10, which is related to what we're going to talk about in this video. I'm also going to post that article that I told you about in class from the Atlantic. And the article, it's quite disturbing because it actually goes into the different ways that that the Trump campaign could challenge the election in case it doesn't go his way. And it's also it's using legal apparatuses to try to get to the point where the election results would not be accepted, particularly if Joe Biden wins the election and he does it because of mail-in ballots. And there are all sorts of ways that Trump could challenge it legally and extra legally, not illegally but extra legally. And it's quite a read. So I'm going to post that on Google Classroom. We'll talk about that in our next live class. So we have this video. I'll post one this weekend, and then I'll also post one for our asynchronous class. So a bunch of videos, and things to read. So please make sure you stay on top of all of it. All right. So we're going to talk today about continue talking about the writing of the Constitution. We spent the last video saying how the Constitution was a bundle of compromises. So after the Constitution was written, full of all these compromises, some that pleased no one, or pleased everyone just a little bit. The next big challenge was finding a way to ratify the Constitution. I know those of you who had me before, I've talked about this a lot. This was my thesis in college, the ratification of the Constitution in Virginia. This was the thesis for my history major. That and the rise and fall of the Whig Party. I had to write two. So the ratification of the Constitution was very controversial. Now the Constitution is kind of seen almost as sacred text, but after it was written, there were a lot of people who really opposed the Constitution and a lot of the principles in the Constitution. There were 55 delegates who were gathered in Philadelphia to write the Constitution. 13 left early and just left because they were just tired of it, I guess. And when the Constitution was finally finished, of the 42 remaining delegates, 39 signed the Constitution, and 3 of them refused to sign the Constitution. And the biggest reason why ratification of the Constitution was so controversial was because there was this feeling that the Constitution made the central government way too big. And they felt that a very large central government is too removed from the people, that it's a threat to their rights, it's way too distant, that the people can't relate to it, and it has so much power over them, but yet it's so distant from them. So it's a similar argument that a lot of libertarian and conservative types today make about the idea of big government. So conservative parts of the country opposed ratification of the Constitution, particularly parts of the country that were concerned with states' rights, because a lot of those folks believed that the new Constitution, by creating this really big central government, was a threat to states' rights. But probably the biggest reason why a lot of people who opposed ratification of the Constitution did so was because they were concerned that the new Constitution did not have a Bill of Rights. Then they said, how do we know what kind of rights we have as American citizens? And what was a particular concern to a lot of those people who felt that way was the idea that, look at all the rights that England violated. That took away from us during our colonial years. So that experience of being a colony was on the minds of, almost everybody who was alive during that time, but especially on the minds of a lot of people who opposed ratification of the Constitution. They said that the Constitution should specifically spell out what rights we have as Americans and should make sure that the new government avoids doing the things that the British government had done to us during the colonial period. Now, 3 states approved the new Constitution immediately. The first one being Delaware. Delaware is very proud of it. They call themselves the first state because they were the first state to ratify the Constitution. January 1788. So 3 states did initially. 2 more did in January 1788. So that's 5 states. It needed 9 states in order to be ratified. And support for the Constitution was very weak in major parts of the country. And because of this, James Madison, Alexander Hamilton, and John Jay wrote the Federalist Papers. And the Federalist Papers, which are one of the most important documents in American political history, the first real, the first real document is, of course, Declaration of Independence. But those are very, very important. At some point in college, you're probably going to have to read those if you take political science. And they just Madison wrote most of them. And he just basically, him and Hamilton and Jay wrote 5 of the Federalist Papers, basically spell out the reasons why the new Constitution is needed, specifically a Constitution that gives the federal government a large role or a larger role in the life of the country. If men were angels, no government would be necessary. James Madison wrote in the Federalist Papers, and I will post Federalist Paper number 10, which is kind of I think the most important. So you guys can read that. Now, the group that opposed ratification of the Constitution were called the Anti-Federalists. Those who supported the Constitution were called the Federalists. Those who opposed ratification were the Anti-Federalists, even though Anti-Federalists could argue with some merit that they were actually the Federalists, because federalism is the idea that we have a central government, but then we also have strong state governments. So the Anti-Federalists actually could make a case that they were actually the Federalists, but the people who supported the ratification of the Constitution took the name first. So the Anti-Federalists emerged, and they said the Constitution gives the government too much power. A lot of them oppose the idea of having a presidency because they say a president could potentially become dictatorial. And they also oppose the fact that the secrecy surrounding the ratification of the Constitution. A lot of them argued, well, this should be an open process. So, like, why was it done? Why was it done in secret? But basically, Anti-Federalists said the federal government that was being created in the new Constitution was too far away from the people to represent them, and also did not include the Bill of Rights. Those were the 2 main reasons that Anti-Federalists felt the way they did. And the views of each side were actually being published in newspapers of this era. And some of the votes in conventions that were called in the different states to ratify the Constitution were actually very close. In Massachusetts, the vote to ratify the Constitution was 187 to 168. In Virginia, that's what I did my thesis on, it was 89 to 79. There were some very prominent Virginians who opposed the Constitution. Even though George Washington was the president of the Constitutional Convention, James Madison, a Virginian, helped write the Constitution. But there's some very prominent Virginians who really did not support the Constitution. George Mason, Patrick Henry, give me liberty, give me death. They opposed the ratification of the Constitution. So that vote was close. New York, our state, the vote was 30 to 27. So that was also a pretty close vote. But all states, all 13, ultimately did ratify the new Constitution. And part of the reason is because the Anti-Federalists scored a major victory when, remember, one of their demands was that there be a Bill of Rights in the new Constitution. And Madison, at first, was resistant to the idea of including a Bill of Rights, because he said, well, if I spell out all the rights that people have, does that mean that rights that I don't mention, they don't have? So that was his objection to including a Bill of Rights in the Constitution, even though ultimately he's, in order to, win over the Anti-Federalists, or at least some of them, and because I guess he felt they did have a point, he decided to include a Bill of Rights. And he drafted the Bill of Rights, which are the first 10 amendments to the Constitution. So amendments 1 to 10, which I'll also post for you. I'll post a copy of the Bill of Rights. Those are our basic protections as American citizens. And those are the first 10 amendments to the Constitution. So just very briefly, and again, I'm going to post on Google Classroom the Bill of Rights, so you guys you'll all have that. the Bill of Rights, the first 10 amendments, Amendment 1 arguably is, well, not arguably, I think it is the most important of all our protections. The First Amendment guarantees you the right of freedom of speech, freedom of press, freedom of religion, freedom to protest. So our basic protections as Americans are in the First Amendment. That's one of the big reasons why it's very hard restricting any type, and I think rightfully, very hard to restrict almost any type of speech or expression in the United States because of the First Amendment. So freedom of speech, freedom of press, we have a free press in this country that can criticize the government, and freedom of religion. And that the government will not establish a state religion. Some people more liberal interpret that to mean the government should have no relationship with religion, while conservative people argue that, well, all the First Amendment says is that we can have one religion. So there's still a controversy over the meaning of the First Amendment in a lot of ways. Some people who are conservatives say, well, it says freedom of speech. It doesn't say freedom of expression, because we do restrict speech in many instances, right? You know, the most famous example, you can't yell fire in a crowded theater, right? You know, there are some limits on pornography and things like that. So threats, you know, you can't threaten people. So the rights are not absolute, even though they're pretty solid. The Second Amendment is the right to keep and bear arms, which is very controversial because it says a well-regulated militia being necessary to a free state, the right to keep and bear arms shall not be infringed. And a lot of, you know, people who support gun control say, well, the Second Amendment says that we have the right to have guns in case we need to join a militia, because this was before we had a standing army. So if the country was invaded, people had to be armed in order to protect the country. Conservatives don't agree with that interpretation. They say that the Second Amendment guarantees you the right to keep whatever guns you want. The Third Amendment says that you cannot be forced to quarter troops in your house. So the army can't knock on your door one day and say, we're moving in and, you know, give us a bed and food. Because that's what the British used to do with the colonists, and they hated that. So the Third Amendment bans quartering troops in your house. The Fourth Amendment says there can be no unreasonable searches and seizures of your property without a warrant. So if the police come into your house and they want to search your house, they just can't do that just because, you know, they feel like it or because they suspect something. They actually have to get a warrant. They have to go to a judge who has to sign, and they have to give the reasons why they want to look through your stuff. The judge has to sign off on it, and then if they do, then they have the right to search. But you can't have unreasonable searches and seizures. That's also controversial because what does unreasonable mean, right? You know, there's debate about that. Right, you know, more conservative people generally believe that, you know, the government should have more power. The police should have more power to search if they feel that something's amiss or something's threatening. While liberal people tend to say that, well, you know, the government, you know, that Fourth Amendment should be enforced very strictly. The Fifth Amendment. The Fifth Amendment, you know, a lot of us know that because when people say, I take the Fifth. Right? I take the Fifth. That generally means that, you know, I'm not going to testify if you ask me a question. What they're really saying is they're invoking their Fifth Amendment right not to have to incriminate themselves. So you can never be made to be a witness against yourself. So if you did something or they think you did something, you can't be forced to help them by giving information that makes you look guilty. You have the right to say no if they start questioning you about something that you did. But the problem is that sometimes when you're invoking the Fifth, it's kind of an admission that you did something, right? Because the Fifth Amendment doesn't say, like, I just don't have to talk, period. It says I don't have the right, I don't have to talk if what I'm going to say is going to make me look guilty of something. So you could argue that you're almost making an admission that you might be guilty of something, even though it's always better to invoke the Fifth if you're guilty, because you don't want to help, even if you're not guilty. I don't think it's good to like help. If they suspect you of something anyway, to help them by giving them information. Almost every lawyer would tell you like to avoid that. But there are some drawbacks because, you know, cops are going to take that to mean that, you know, you're almost conceding that you did something. But there are other rights of the Fifth Amendment too. No double jeopardy. You can't be charged with the same crime twice. So if you're accused of something, if you're accused of assault and then you're acquitted, they can't decide that they're going to charge you again with assault. Once you're found not guilty, then that's it. They can't charge you for the same crime twice. That's double jeopardy. You have the right to due process. If you're accused of a crime, then you have to be indicted, you have to be charged with a crime, you have to know why you're being arrested, you have to have a trial, they have to find you guilty and or not. So all processes have to be followed if they think you're guilty of a crime. That's what due process means. So the Fifth Amendment guarantees that. The Sixth Amendment says that you have a right to a speedy trial. So they can't just keep you lingering forever, even though that often happens in our justice system, unfortunately. People are in Rikers and jails for forever, waiting for their trial date. That's, not arguably, I think that is a violation of the Sixth Amendment, which says that you're guaranteed a speedy trial. Even though there's such log jams in courts today, that is, sometimes you wait months and months for a court date. You have the right to a jury. If you're accused of the crime, a jury of your peers gets to decide whether you're guilty or not a judge. So 12 people who are from the community, who are supposed to be people like you, are the ones who get to decide whether you're guilty or not guilty. You have the right to cross-examine witnesses. If somebody says that you did something, you have the right to then question them. They can't just say whatever they want without a response from you, that you have the right to cross-examine them. You have the right to question them yourself if they're giving testimony against you. You also have the right in the Sixth Amendment to a defense lawyer. You have the right to counsel. Before 1964, that was interpreted to mean, well, you have the right to a lawyer, but that doesn't mean we have to give you one. After 1964, in the Gideon versus Wainwright Supreme Court case, the Supreme Court ruled that if you can't afford a lawyer, you have to be given a lawyer. That's the part of the Sixth Amendment, even though that's not the way it was interpreted before 1964, at least by most states. The Seventh Amendment says that you have the right to a jury trial in civil cases. Remember, there's two types of cases. There's criminal cases and there's civil cases. Criminal cases involve a violation of criminal law, which can result in you being imprisoned, losing your liberty. A civil trial is when you're accused of owing somebody money. So you can't lose your liberty. You can just lose, money if you lose the case. You have the right to a jury trial in a civil case as well. So that's the Seventh Amendment. The Eighth Amendment bans cruel and unusual punishment, saying that this cannot be inflicted on you. But again, this is subject to a lot of interpretation as well, because a lot of people say, well, what's cruel and unusual, right? A solid case can be made, the death penalty. Nothing is more cruel than killing you. But conservatives say that's not cruel and unusual punishment. And then there's a variety of other, things, torturing suspects, giving, making people not giving them food and water, trying to get them to talk, excessive sentences. So there's a lot of debate over what that means. And I hope you're seeing here, that, these amendments are not ironclad. There's a lot of wiggle room that can be argued either way in a lot of these amendments. You cannot be charged excessive fines or excessive bail. Remember, bail is what you pay to get out of jail after you're arrested, and you get to wait at home until your trial starts. So bail cannot be excessive. That's becoming a very big issue now. New York State eliminated cash bail, a couple of years ago. Conservatives were enraged by that, but liberals said that, well, you're innocent until proven guilty. Right. So a lot of people were arrested, then couldn't afford bail, but and as a result, they have to stay in jail until their trial, which could be 4 months, 6 months, a year. And in the meantime, you're in jail. So, that's very problematic. So that's the Eighth Amendment. The Ninth Amendment says that just because, remember, this was the reason why Madison was resistant to the Bill of Rights in the first place. The Ninth Amendment says that just because some rights are mentioned in the in the Bill of Rights, that doesn't mean you don't have other rights. You remember that was like a reason why he was a little resistant to having a Bill of Rights. The 10th Amendment, which is one that conservatives today really like, it says powers not given to the federal government specifically are given to the states and the people. So those are conservative, and those who believe in states' rights say that actually does empower states a lot more than a lot of big government people would like. That the states actually have a lot of authority, unless a power is specifically given to the federal government. But that's subject to debate as well. I'll post all these amendments so you guys can read them. It's totally worth it because everybody should know your basic rights as Americans. But a lot of them are up for debate. Like they're not ironclad, and that's important to remember. A lot of these, and they're not absolute either. And there's a lot of them can be argued. Either way. But these are our basic rights as Americans: to protect political opposition, to protect against an autocratic government, that you have the right to speak out against them, and also to protect you against a government that could potentially take away your liberty. Well, government always can do that, right? You could be arrested and they could put you in jail. So if that happens, you are guaranteed some basic protections as an American citizen. The Bill of Rights is extremely important. It is basically your protections as an American citizen. So that's and I'll post that, and then you can kind of read them on your own. The Constitution, it's important to remember, did not. I know we've been talking in our live class about the undemocratic elements of our government that are written into the Constitution. But some people might argue that, well, America was never supposed to be a democracy, that America was a representative republic. We're a republic, right? We elect people who then make decisions for us, right? We elect members of the House, members of the Senate, the president, and then they make decisions for us. We don't vote directly on issues. Some states allow people to do that. In fact, a lot of states do. And that's called a referendum. So that is an example of direct democracy. Like, should we expand Medicaid? That's actually been on the ballot in a lot of states and has passed every state, including a lot of conservative states. So that's an example of direct democracy. Those things weren't really implemented until the progressive era in the early 1900s. But America really wasn't supposed to be a democracy, right? We're a republic, and a representative republic. People would elect their own representatives who would then make decisions of state for them. All right, guys. So I don't want to move on to the next topic because that's quite lengthy. So thank you for watching. Remember, I hope you watch this start to finish. Check Google Classroom because I'm going to be posting a whole bunch of stuff on there for you guys to read. And I'll do in our next video I'll post this weekend, and then there'll be another one on our asynchronous day. And I will see you. I'll see you on Thursday for our next live class. All right. Peace.